This webinar is jointly organized by Law Society Pro Bono Services, Charity Council, and Office of Commissioner of Charities. My name is Serene, and I'm the moderator for this webinar. First, some housekeeping matters. Please feel free to ask questions at any time during the webinar using the Q&A button. We will do our best to address your questions during or at the end of the webinar. Kindly note that today's discussion and materials do not substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. I'm honored to introduce our amazing panel of speakers for today. Francis Wong is the Director of Strategy and Governance for Dementia Singapore. He joined the dementia movement in 2013 as the Asia Pacific Regional Director with Alzheimer's Disease International before moving to Alzheimer's Disease Association in 2017. ADA for short. ADA is a society which transitioned to a company limited by guarantee known as Dementia Singapore Ltd in September 2021. Prior to that, Francis was with the Centre for Nonprofit Leadership after leaving his corporate life. Peggy Yee is a member of the Charity Council and is passionate about providing assistance to the disadvantaged through the many social causes that she is involved in. She is the Vice President of the Disabled People's Association and also sits on a number of boards of other charities and social organizations. She is also a lawyer in private practice for more than 30 years. Samuel Yuen is the Managing Director of Yuen Law LLC, an award-winning Singapore law practice specializing in legal issues relating to startups and emerging companies. He is the head of its corporate practice group. Since starting his practice in 2001, Samuel has earned a reputation as a creative but pragmatic practitioner of law, who is able to provide effective legal solutions. Samuel is also active in the local business and charitable communities. Thank you, Francis, Peggy, and Samuel for joining us today. Today, we will follow Amanda's journey of transitioning the legal entity of her charity. Amanda is the operations manager of Happy Charity. Happy Charity is a registered society. 7 of its 13 office bearers stepped down, and Happy Charity has difficulty finding replacements. Amanda's friends suggested that perhaps Happy Charity becomes a company limited by guarantee because it only requires a minimum of 1 director. Samuel, is that true, what Amanda's friends said?
Well, Serene, thanks for the question, and it's great to be here. Amanda's friend is both right and not right at the same time. Let me explain why. Yes, it is true that the Companies Act only requires 1 member and 1 company secretary and a minimum of 1 director. So it's just 111. However, if you are talking about forming a or getting registered as a charity or being recognized as an IPC, the standards are somewhat different. So the minimum is 1, but often if you are registered as a charity, in fact, if you are registered as a charity, you find that you need at least 3. And if you are running a large charity like what Francis Charities ADA is, you'll find that the recommendation is actually for 10, minimum of 10 directors or 11 directors. Yeah. So he is not wrong, but yet at the same time, he's just scratching the surface of it.
Thanks, Samuel. And I think that's quite consistent with, friendly advice given by friends, family, or strangers that good to listen to them, but also to check whether what they say is true. Well, Samuel, besides the number of directors, are there any other legal differences between a society and a company limited by guarantee?
Oh, yes, lots of differences. And what a lot of people do not know, registered societies are actually created under the Registered Societies Act, which for those who are old enough, you will remember that this was created at a time where there were basically a lot of criminal gangs in Singapore. And this registered society was created as part of the answer to controlling, gang activities. But of course, over the years, you'll find that we don't really have that problem anymore. And we do, however, have this issue where societies form that tend to have a minimum or require a minimum of up to of around 10 office bearers. And this is perhaps the main reason why I would find a registered society to be not so attractive. Yeah, it is difficult enough in any charitable landscape to find volunteers, right? Much less volunteers who are aligned to your ideas and ideals. It is very difficult to, of course, have this constant renewal and a constant, bringing on of en masse a group of office bearers. So that is where the main one of the main differences is between a registered society and a company limited by guarantee. Legally speaking, your CLGs, company limited by guarantee, require one, and if you are registered as a charity or you're awarded IPC status, then of course it goes up accordingly according to the code of corporate governance. The other main difference that I would want to highlight at this point is the fact that CLGs are what we call separate legal entities. Yeah, so legally speaking, that there is a very clear demarcation between the CLG, company limited by guarantee, as opposed to your person, your own legal personality. This means that a CLG may sue or be sued in its own personal name. Yeah, members of the CLG will be protected from any liabilities incurred by the CLG up to the limit that has been stated in its constitution. And that is what you guarantee, yeah, okay? And hence, companies limited by guarantee. On the other hand, depending on who you ask, but the general consensus seems to be that in a registered society, personal liability, or rather the liabilities of the registered society may exceed what the registered society has, and it may become personal at some extent. I also mentioned earlier that, because of the separate legal personality, CLGs, right, are able to hold properties on its own. And for those of you who are familiar with a registered society setup, you'll find that there's always a trust committee or there is a trustee to hold the assets. Of course, that can be open to abuse. And it is something that has to be navigated very carefully. Yeah, back to you, Serene. Yeah.
Thanks, Samuel. So I think in summary, you've highlighted quite interesting points. So first, of course, is you don't need perhaps as many office bearers when it comes to a company. Although noted, depending on the size of your charity, you may need more than what is ordinarily required. Second,
Yes.
and I think more importantly, is that when you talk about legal liability, because a company is a separate legal entity, so that means if it enters a contract, if it gets sued, it would be under the company. Whereas for society, the members are on the hook actually. So the members are probably responsible if the society goes into any trouble or liabilities. And I think lastly, as you mentioned, the good thing about a company is that perhaps from a longevity perspective, the company can directly own property, they can directly enter the contracts, so the company can move on. Whereas for society, as you mentioned, it will be a group of trustees who would own the property. And of course, question mark what will happen when people perhaps after some time leave the charity or move on to other things might be very cumbersome. So beyond the legal point, Francis, you've gone through the process, where ADA went through from being a society to a CLG. Any additional thoughts on perhaps any possible benefits or drawbacks of being a CLG compared to a society?
Hi, Serene, thanks. And good afternoon, everyone. I'm so glad I'm at the tail end of the journey. Someone told me, MOH also, the sector administrator said, it is not rocket science, but there's a lot of work to do. So just to your question, so in our case, it was not unlike Happy Charity. Our case is to move from a society to CLG was not due to recruitment of board members. We had basically three key reasons. One was the CLG offered us a flexibility in terms of our operations because we were growing, we are growing, and we were toying with the idea of perhaps opening a training academy, could be in another country in Southeast Asia, because our friends, our partners in various countries have come to us regularly over the years to seek training in terms of dementia care. So we've, with a company structure versus a society structure, a company structure offers more flexibility. And then what Samuel said about the personal liability, when we started 30 plus years ago, it was a very, very small charity. Now last 2 years ago, we exceeded the 10 million mark. So we're considered a large charity and an IPC. So the liabilities or the risk is increased. So we felt that we should reduce or even eliminate personal liability. And really, there was no necessity for a large membership base anymore. So that was more or less the reasons why we made the decision, and we see a lot of benefits as a CLG. Yeah.
Thanks, Francis. That's a really good insight. I mean, I think it's something that only someone who's been through that process and the thinking, decision-making can share. In that, as you mentioned, you may not need as many members, and also flexibility if your charity wants to expand, perhaps even collaborate, even go overseas. Peggy, does the Charity Council have any thoughts on the type of corporate entity adopted by charities?
Hi, Serene. Thank you for the question, and thank you for having the Office of the COC represented this afternoon. Now, first off, I must say, as far as the COC is concerned, the COC does not dictate nor mandate or direct that a charity must either be a society or a CLG. And if a society is already a society, if a charity is already a society, the COC does not also mandate or lay down strict directions to say that you must incorporate yourself into a CLG. As Francis has said, each charity will have its own objectives. So one of the objectives that we've just heard Francis mention is that they saw no need to maintain that membership base, and then they wanted to eliminate liability as well. So CLG was the way to go. So for each charity here, you would need to look at your own objects. And find out the concerns that you have as well, in order for you to make that considered decision whether or not you are going to incorporate yourself as a society or a CLG, or if you are already a society, whether or not you are going to transition into a CLG.
Thanks, Peggy. So it's very much CLG is a possible tool, a possible structure that a charity can consider, but it very much needs to decide on its own what is a more suitable type of structure that it would like to use. Francis, we just received a question from an audience member, and they were curious, about your thoughts. They mentioned, you had mentioned that, there wasn't a need for such a big membership base. So what do you mean by that?
Okay, so I'm talking 30 years ago. That was even more or less pre-internet days, right?
Yes.
For anyone who wants to know more about this topic, and again, 30 years ago, not many people knew what dementia was all about. So we had family caregivers, we had clinical professionals joining as members, so that a few like-minded people or people who are very curious about the topic would be able to find out more as society members. There was, I think, even in some charities, the society provides services for their members. So if you want to provide for people who are not your members, is a different story, right? But now you move forward 30 years later, you don't need to be a member of our charity in order to find out more about dementia, in order to come for our training courses, in order to go to our dementia daycare centers. So actually, membership does not have its privileges, if I can say, unlike 30 over years ago, where it was much easier for the charity to provide engagement, ongoing engagement to our members then.
Thanks, Francis. So it sounds like it's pretty historical reasons that perhaps, in its genesis, when it first started, as you said, 30 years ago, in order for you to enjoy certain services, you became a member of a society. Whereas for a charity or CLG, you don't need to be a member in order to enjoy its services.
Mm-hmm.
Correct? I mean, I assume that...
No, not true. So as a society, you can also provide services, benefits to people who are not your members.
Okay.
It's just that we started and we grew our membership base, and later we said, you really don't need to be a member to have everything you need or you want to learn. You don't need to be a member anymore. So we stopped membership actually for a couple of years already, because we really felt, you don't need to. It's very cheap. It's like $20, right? But you don't need to pay this annual $20, because we were becoming a 10 million charity. So really the $20 also wouldn't make an impact. So what would be the real purpose if someone says, I want to join, and we had cases, they say they want to join. And when we ask them why, they say, oh, so I can learn more. And we say, well, you don't need to join, you can learn more. So we already stopped that. So it was quite natural to say, if we're going to stop increasing the membership, and then we have a lot of older members who has moved on,
graduated
from this life.
Yes.
So there was really no specific purpose why we needed a large membership base.
In fact, if I may just add on to what Francis has said,
sure.
Over the past 2 decades, ever since I started practice and got involved in charities, right, I noticed maybe you can call it a paradigm shift, where clearly it has moved from membership to clientele. And I noticed that some of the newer charities, right, view the people that they serve as their clients, as opposed to being members. Like what Francis said, it used to be membership has its privileges. But I think there has been maybe a change in thinking. But whatever it is, right, certainly from a legal perspective, right, it makes more sense to have a smaller client base. I remember as a young lawyer serving charities, we had to trace, because some of these members have actually been uncontactable for a few AGMs, and the register was getting cluttered at some time with members who are actually like non-members, but they are still on the roll, you see. And that's when what Francis said, they graduated and they have moved on from this earth, and that membership is no longer valid anymore, you see. So the charities will, the larger your client base, the larger your membership base, the more you run into this kind of problems.
Thanks, Samuel. An audience member pointed out, as a clarification, in terms of the members' liability for society, probably we had to consider, I think they mentioned that basically, ordinarily, if a society is in debt, etc., they will first claim out of the society's property rather than out of the members, perhaps only in exceptional circumstances where there's fraud, for example. Any thoughts on that?
Should I answer that first?
Sure. Yeah, go ahead. Yeah, this is a question for you.
That is not wrong, In fact, that's why I would say that that there is this poll over the registered societies setup, right? Because yes, at the beginning you claim against the society, okay? Just like how in a CLG, if there are liabilities, you claim against the CLG, right? But at some point, right, you come to this point where maybe whatever is being claimed is more than whatever is available in the organization. And that this is where it starts to have, there's an inflection point, yeah. For registered society, in that kind of cases, legally speaking, the members are actually liable for the debts of the society. However, for the CLG, because constitutionally you have already agreed to guarantee up to a certain limit, right? And that is the extent of your liability. So if it works out to be $1 million per member, constitutionally, the CLG would have limited it to less than that. Usually I see in CLG constitutions, it's maybe up to 1,000. So I think that is where the difference is, yeah, in terms of liability, yeah.
Thanks, Samuel.
Serene, just
Yes.
Serene, to add on to what the two gentlemen have shared. Perhaps the charities can also consider, because Samuel has pointed out the differences between a CLG and a society. One of them is actually, and this connects with Francis's point about whether or not there is a need for a wide membership base, because then we want to think about voting rights. In the charity for the charity in question, they want to ask themselves, perhaps, is voting rights essential? Because only a member can vote. So if the situation is such that voting rights are crucial, then you may have to remain as a society, or you may want to incorporate yourself as a society instead of a CLG. That's one point. But also from the COC's point of view, the recent climate right now, we have been getting a bit more inquiries from our partners as to transitioning from a society into a CLG, or whether they should incorporate themselves into a CLG from the outset. So this webinar is really timely. Thank you.
Thanks, Peggy. I just received a question from an audience member, and I thought it's good to clarify this question the audience member has. What's the difference with an IPC and a CLG?
I think.
Okay. Oh, sorry. Maybe I'll ask Samuel. IPC and CLG. I think it's quite different, but maybe we can hear from you.
Sure. Okay. A CLG is a legal entity. Okay. To put it very simply, IPC is a status accorded by the authorized organization or authority to give you a certain tax, to give you tax exemption for your donors. Okay, so this is actually a status as opposed to a organization or legal entity itself. Yeah. So a CLG may be an IPC, a registered society may be an IPC.
Thanks, Samuel, for that clarification. I thought it's good that we clear that before we move on with the webinar. Sorry, Peggy, did you have something to add?
Oh, as far as an IPC is concerned, you see, if we're talking about a whole basket of charities, then charities can either be incorporated as a society or as a CLG. And Samuel is right that it is whether or not you're an IPC. If you're an IPC, the status of an IPC means certain things. Chiefly, it would be that there are tax benefits given to this charity that it has been accorded IPC status. It can give TDRs, tax deductible receipts for the donations that it receives. It would also be useful for the audience to know perhaps that as an IPC, IPCs are charities that would benefit the local community only. So if you are a charity embarking on overseas missions and you are fundraising, for example, or your mission is overseas, then you cannot be an IPC, nor can your objects be secular, for example, because IPCs are for there should be no race, no religion based, so it should be for all in the community. So for example, religious charities would not be IPCs. Okay.
Thank you, Peggy. I didn't know that. Okay, that's good to know.
Yes, but I think maybe just to add on to that, right? But
yes,
a religious organization may actually encourage its members to form an IPC for the greater good. Yeah, like one that I'm aware of is, say, like a New Life community, where I understand most of the members are actually maybe church members, or they go to the same church, but the services that are offered is actually for all, regardless of race, language, or religion.
Thanks, Samuel. Noted. Let's move on to the next step of our scenario. Amanda proposes to Happy Charities Management for Happy Charity to become a company limited by guarantee. The Vice President asks, who should become a director and member of the company limited by guarantee? So Samuel, from a legal perspective, how does that work? Is it compulsory that all the office bearers of a society will automatically become directors of a CLG?
Not necessarily, because earlier, as we highlighted, there is actually a difference in the minimum requirement. I would go as far as to say that you pick the bare minimum, because sometimes when there are too many individuals, it is harder to meet, right? So you also have to consider the efficacy or the efficiency of the board in meeting. But the following might actually be useful, okay? And this is actually taken from the Board Appointment Guide for Charities and Charities Unit, okay? This is a publicly available document. And what it says is that when you are selecting board members, pay attention to the following. Relevant skills. Look for relevant skill sets and experience useful for the charity's services and operations. Relevant skills will involve, say, fundraising, legal, finance, accounting, human resources. Personality trait, determine the ideal traits and characteristics of the chair and and the board's members, whether such as, for example, integrity, alignment, ability to forge consensus, and whether they have a good working relationship, whether they are disruptive, for example. You should also pick board members who are independent from the staff working for the charity. And this can be quite an important point. You do not want a conflict of interest in the charity, because it is, it's not good for the organization. Lastly, the guidelines also recommend diversity. Okay, embrace board diversity in the form of technical expertise, gender, age, ethnicity, and other forms of demography to provide more diverse perspectives. I think I speak for myself. If it's a charity of 10 Samuels, I think it's going to be very badly run. So we need the diversity to help the charity reach greater heights. But legally speaking, okay,
Yes.
It is not compulsory. Okay, it's not compulsory that all your office holders of the society become the directors. Although, maybe an easy go-to is actually to transplant the existing organizational structure in or the office bearers. You move them all into the CLG, but legally speaking, there is really no need for it. Sorry.
Thanks, Samuel. So I think in short, from a legal perspective, they're basically free in a sense to choose a new board of directors for the CLG. They're not obliged, or legally obliged at least, to make every office bearer of the society become the director. Am I right? Similarly for members as well, you don't need to make every member of the society becomes member of the CLG?
Legally, you do not have to, but I think Francis may have something to say here, because from his practical experience, it might be different,
Yes, for sure, for sure. So it's good to get that legal perspective from you. So Francis, I suppose, sharing from your past experience, any tips in terms of for a charity to consider how they go about choosing the directors and the members of a CLG?
Okay, happy to share, but disclaimer, my total experience of bringing an organization from a society to CLG is one.
Yes.
So I'm not speaking on behalf of the entire sector. I think all charities, you need to know your own situation. So in our situation was for many years, at every AGM, although we had about 200 members in the society, we could hardly meet the quorum. We never ever met the quorum, right? If I can say that.
Yep.
And the loophole, of course, you break for makan, you wait roughly about 1 hour, then we resume the AGM, then it's valid, right? Because we don't hit quorum. So in our case, we already had an idea that the membership, we're not going to move everyone. In fact, as a member, we wanted a small membership base. What is small? So that was a bit subjective. We collectively, I mean, the board and all collectively decided small, let's not go more than 10. So the number became 9. Okay, no scientific formula.
Yeah.
It was just, let's keep it small. Okay, so now I go back to say, from 2018, we already had our internal deliberations and we talked to various members to get a feel. In the 2019 AGM, we shared the story. We didn't pass any resolutions, right? And we gathered even more questions from those who attended the AGMs. It was only in 2020 then we started passing resolutions to incorporate the CLG, right? So that means we brought the whole membership, well, those who were attending and those who were interested to know, we brought them through that whole journey of understanding, and we tried to address any of their concerns. One of the concerns came up was that, will we have a change in our mission, a change in our charitable objects, right? And we said, no, nothing changes. The board, so in a society, we don't call them directors. Directors are for companies, right? So for the board in a society, we call them the management committee, and they are elected at AGMs. And all management committee have to be first a member, then they can stand for election. That's how our constitution is written. Okay, I don't know whether it's a legal issue, but I follow the constitution like my Bible, right? Which means we brought we had 13 board members from ADA, Alzheimer's Disease Association. We brought them all to be directors, the board of the CLG, which is Dementia Singapore, right? We said, so nothing changed. All the staff moved, same CEO, same management team, charitable objectives, exactly the same. When we rewrote the constitution, we did not change the first part that says, what are the objectives of the organization. All our services, everything was the same. So during the AGM, the members were very comforted. Okay, and who becomes a member? So we also asked around, and we knew that there are some members who are very, very well respected, well regarded, as they care. I mean, everyone knows they really care for the families that we serve. So we invited them to be the members. We had 1 or 2 members of the society that were very insistent to keep their voting rights. And we said, okay, let's not kick up a big fuss. If they really want to, why not? And what was great is we came up with a scheme, and we wrote this in our constitution, that we will have 2 levels of membership. One is called life members. So those that, everybody respects, everybody trusts, reputation, they know the dementia cause, they are even well regarded in the overseas, the various Alzheimer organizations overseas. We gave them life membership. Then we had another category called term membership. And we say term membership means we give you this, but you only serve for up to a certain term. Then the question was, how long is one term? So we just flip open the Charity Code of Governance and say, hey, 10-year limit for board. Okay, we also put 10-year limit. So how we constructed it was for our own needs. And all the members were very happy based on what we shared. And yeah, I think that's the story of how we move. But just one point on directors, Serene.
Yes.
So in ADA and now, of course, practice in Dementia Singapore, we do not parachute a board member in. It is documented in our policy that they have to first serve in a subcommittee. So there must be a paktor period before we get married, right? Not only for us to know them, but for them to know us. Because if you sign up as a board member, and then you find that it's not what you want, the culture is no good, it's not very nice that you say, okay, then I quit, right? So we have this subcommittee, serving on a subcommittee for about a year or so, then everybody knows everyone, we are comfortable, and then they can move and join and be put up as a candidate as a board member.
Thanks, Francis. Thanks for sharing your journey. Again, to our audience members, in a way, you can tell that it's really very much about knowing your stakeholders, managing them, managing relationships, and knowing the people involved. So, it's still a very good insight, Francis, in terms of how you were quite creative in trying to find a solution that was acceptable to everyone. And I think it was also a useful reminder that you don't need to be a director to contribute. You can be on subcommittees. You don't need to be a director. And I thought that was something, a good reminder that I picked up from what you shared with us. Peggy, does the Charity Council have any guidelines or rules on the choice of directors and members?
The COC's objective is to ensure that every charity is run well, so that its management practices are good and robust, and that its governance policies are also strong, robust, and effective. And because the COC's office is not dictatorial, and it allows charities to run themselves, but what it does though is to provide support by providing, especially the smaller charities, because at the end of the day, Serene, we all know that those who are in the charity sector, we all want to do good. But in doing good, is everyone suitably qualified as far as governance and management is concerned? Maybe not. And for those instances where the charities do not have resources of manpower or funding, that's where the Charities Council has come up, the Charities Unit actually has come up with, and Samuel made a reference to this, we have the Code of Governance, which really is like a best practices guide. So it sets out, firstly, to look at the Code of Governance, look at it this way, and it's available online on the Charities portal. It first sets out for all charities, it sets out the 9 governing principles that each charity should look at. And I say should because, remember, we do not mandate. Although there is law, there is the relevant legislation that governs charities, the Charities Act, the Charities Regulations and all that. But back to the Code of Governance. So it sets out the 9 principles of good governance. And these 9 principles would be things like board governance, strategic planning, program management, financial management and internal controls, disclosure and transparency. So when it comes to board governance, it also gives you an indication, it gives you guidelines as to what the charity ought to do in selecting its directors. It also gives you guidelines on how to avoid a conflict of interest and guidelines as to how you ensure transparency, because at the end of the day, the charity does not exist by itself, right? It has to connect with its members, with the community, with the public, and also with donors. So when you look at all these different spheres, when everybody works together, then this charity, armed with good management and governance practices, will then be an effective and sustainable charity. And that's what the charities, the COC, is hoping to see to create this culture in Singapore.
Thanks, Peggy. We have a question from the audience member that for CLG charity, how is it accountable for the millions it has? Is there any audit or policing done to safeguard the monies? I suppose perhaps they're wondering, is there less safeguards because you go into a CLG instead?
Perhaps I can start off first by, sorry, I'll just.
No, it's okay. Yeah.
Because charities are divided into different bands. We have charities that perhaps where their total expenditure or their gross receipts are less than 50,000. Then there are certain then they're exempted from certain reporting. Then there are charities from 50,000 to 500,000, from 500,000 to 10 million, and charities that have total receipts or expenditure of more than 10 million. So these charities are banded, in these different tiers, and there are different reporting responsibilities that are set out for each of these banded tiers or charities. So whether you are a charity that's which is a CLG or a society, so long as you know which tier you are in, then those reporting policies and those reporting guidelines would apply to you. So, for example, a CLG charity that is in the large charity tier of more than $10 million, the reporting responsibility and onus is a lot higher than that of a charity that has receipts of, say, less than $50,000.
Thanks, Peggy. So I think in short, regardless of whether you're a CLG or you're a society, you still need to comply or take guidance from, as you said, the code of governance. It doesn't mean just because you go to a CLG, suddenly there's no audit, there's no checks.
Yeah.
Samuel, you wanted to add to that?
Yes, in fact, right, the CLG is treated like a public company. Okay, so the general rule is that under the Companies Act, public companies and CLGs must be audited as well. Yeah, so I think you can't run away from the audit requirement. It is the rigor for charities in Singapore.
Thanks, Samuel. Well, the next part of our case scenario, so we heard from the Vice President. So now we hear from the President. So the President says that Happy Charity has different arms. It has one arm which provides free childcare services for the poor. It has another arm that provides free daycare services for the elderly. And lastly, it has an arm which sells educational materials to raise funds. So you can see for this particular charity, they have three different things or activities that they pursue. So the President asks, so should these different arms be broken up into different companies, or perhaps all still chucked under one CLG? Well, I suppose, Samuel, from a legal perspective, are there any legal benefits or drawbacks to breaking up the different activities as opposed to just consolidating it under one CLG?
Well, legally, there is actually no requirement to break it up. Yeah, a company or for the matter, any separate legal personality can hold multiple and varying interests, right? You're not beholden or forced to only take on one kind of activity. Without going into too much detail, that is the stand these days, yeah. And I feel that whether you want to split it up or not, it really depends on the size of the operations. So let me just use an analog here. For private companies, let's say I offer 3 types of buns for sale. The red bean bun is very popular, and I find that I have to dedicate multiple lines of production just to keep up with demand. And over time, it might make sense to hive it off as a separate company. And this is something that MNCs like Hewlett-Packard, and the big ones, they do from time to time. When a division has grown too large, or they have taken on sufficient resources, they hive it off and form a new company, right? So in that with that perspective in mind, if your one particular arm has gotten big and it is actually taking up resources that could have been meant for the other 2 arms or divisions, then consider, right? Maybe hiving off might actually be a good solution. But the moment they are formed and they are, maybe bringing in like $5, $10 a month, there's no real point in hiving it off, because the administrative cost alone will far outweigh whatever you're earning, at the beginning stages.
Thanks, Samuel. Francis, any thoughts to add? Especially when you mentioned that ADA had a few things they were looking at.
Okay, so this is really subjective, right? It depends on your own situations. What Samuel also said, it depends on the size, depends on the aspiration. So for our case, we are saying that down the road, maybe, I mean, we have not signed anything, but maybe we'll set up a regional training arm for dementia care. But it's, Singapore is Singapore, and we work very closely with AIC and MOH, so I think it's very well covered. But there are many countries out there, Malaysia, Indonesia, Vietnam, etc. And we're all part of this global membership, and they're saying, please help us, right? So if we were to set up a regional training arm, I think Peggy said as well, right? We're going to benefit people not in Singapore. It's not going to be IPC, definitely. It's a training company, but it can be wholly owned by Dementia Singapore, and they can channel, some of its profits, hopefully make money, right? Channel its profits as a donation back to the mother company. I mean, these are all really, right, down the road. But what we're just saying is the company structure allows a little bit more flexibility. That's what we were advised, and then we went with that. But breaking up or not breaking up, it really depends. I think Samuel is spot on. If it's really large, and you may want to consider a separate board of directors that have that specific skill set or knowledge, like a very technological, for example, where the rest of your board are lost when they talk about techie stuff. Maybe then you spin it off, right? You have a different board of directors. But with every split, you get more and more headaches. Don't think that you have multiple companies and multiple boards is a walk in the park. No, it's actually very challenging.
Thanks, Francis. Peggy, from the Charity Council perspective, any preference in terms of a charity that has separate entities instead of one combined entity, or it's all the same, or it's up to the charities?
Okay, the answer would be number 3. It is up to the charity. So it really is for the charity itself and for the management and its members working together with its stakeholders to decide what is your direction. So I cannot emphasize enough that the charity must be very clear as to what its mission and objectives are, and its strategic thrust. How is it going to get there? And that will help it to make that decision as to whether or not to break up all these different arms, or can these arms just work together in one entity.
Thanks, Peggy. Samuel, Francis touched on, if you have too many subsidiaries and a conglomerate, it may be very hard to coordinate. Perhaps even for some CLG, you might consider having a different board. So I think one key question is how, after all, they all came from the mothership or a particular charity. How do you try to exert control over all these different CLGs or societies?
Well, legally speaking, and I come in from that perspective first.
Yes.
It is always, if you want control, it is always about putting your guy on the board. It's always about having that undeniable and irrefutable presence at the board level, and in some cases, even as members. Yeah. That's how you maintain control, but there is no subsidiary or holding company, as in the case of companies limited by shares, right? Because I have to highlight this. Companies limited by shares, okay, if you are a shareholder, you are a member, and you are also at the same time a part owner of the company. Okay, yeah, you own parts of the company, the whole and yet in part, yeah. But for companies limited by guarantee, you may be a member, but you are not an owner, right? Because all you do is guarantee. You do not buy shares, but you offer a guarantee, which may be called upon on you to make good that guarantee at a later date. You see, so that is the difference that we have to appreciate. Yeah. So you do not have a structure where a CLG becomes a subsidiary or holding company of another CLG. However, a CLG legally can hold shares in other private companies. Yeah, as strange as that may sound, because you have that separate legal personality, the right to sue, to be sued, to hold assets, and to dispose of your assets. Yeah. So that is one clear, as I mentioned right at the beginning, one clear difference between a registered society and a CLG. Registered society can do all these things through the auspices of a trust committee or a trustee.
Thanks, Samuel. So that's really interesting. I didn't realize that you can't have a so-called parent like the CLG can't be a subsidiary. So as you said, basically, if you really want to maintain some sort of control or consistency across different CLGs, it's more of looking towards the board of directors.
Yes. And the other way of doing it is to look at the constitution of the entities and create alignment. Without going into too much details,
Sure.
of course, we did away with the ultra-virus doctrine many, many years ago.
Yes.
I know it's like law school coming back to haunt you. What you can do as a prime mover in these CLGs is to actually align the constitutions, to make sure that you set out the purpose, right? And also at the policy level of each CLG, maybe dictate what that purpose is as well, right? So make sure that there is alignment. Yeah.
Thanks, Samuel. Let's move on to our next part of our case scenario. So now we move to the secretary who asks Amanda, must the Charity Council approve the change that now it used to be a society and it wishes to set up a CLG? So Peggy, what's your thoughts? Does Charity Council need to approve this change?
Well, the short answer to this very specific question is no. Any charity who wishes to embark on this process of transitioning from a society to a CLG, there is no application, as it were, to be made to the COC. What it needs to do is to work together with its sector administrators, and then go through the process with ACRA, because you need to do the legal part of it, to wind down, to close down your society, and then to incorporate the CLG. So short answer is no.
Thanks, Peggy. So Charity Council does not need to approve, but you do need to go and consult and work together with your sector administrator.
Yes.
Sorry, Francis, did you want to say something?
Yeah, I just want to emphasize, you really, really, really should work closely with your sector administrator, because there's nobody who does this every day for a living. Many things you won't know, right? So really, they are very nice. They're very supportive. Well, at least our sector administrator gave us a lot of their time and responded very quickly. And you just say, we want to do things right. And in the end, they approve anyway. They have to do the approval. So involve them early. Even way before our first AGM, we already involved and we asked them for advice. Right?
Thanks, Francis.
Serene, can I just add this as well? In addition to that, to the conversation that the charities should have with SAs, with the sector administrators, to get that to get them on board, and to get their consent, that same conversation can run parallel with the conversation with the office of the COC, where there will be people who can also help to guide them along and to point them to the right resources. So that's something for charities to consider as well when they start embarking on this journey. Because really, and I just took a quick look at the questions, it is not, the waters are not so muddy. It may seem like a lot, but if you take it one block at a time, it is actually quite manageable.
Thanks, Peggy. Noted, get your sector administrator involved, and although Charity Council does not need to approve it, please feel free to reach out if you need to just consult with them.
Always get the sector administrator involved. You don't go into the kitchen without saying hi to kitchen god.
Okay, so next, for our case scenario, we have the treasurer, most important. So the treasurer asks Amanda, what is the process like to basically go to a CLG, and would it cost a lot of money? So Samuel, perhaps from a legal perspective, what is the process? How does the society become a company limited by guarantee?
Yeah, this is, I think.
And how much do you charge, Samuel? How much do you charge?
I'm here for charitable purposes. I think this is a very important question, because as I was scrolling through the Q&A, I find that a lot of people want to find out. So the starting point is always this. Bear in mind, the registered society is not the company limited by guarantee. They are two separate and distinct organizations. Yeah. So you cannot convert, so to say, okay. The conversion process, right, is actually more like killing one, okay, and giving life to another.
Yes.
Right. So without going to a lot of details, because I'm not sure if we have the time for it, it would be akin to, say, the registered society dissolving, and at that point of dissolution, agreeing to transfer all of its assets and its contracts and whatever it is into the CLG, right? This is in line with how our laws are. Okay, if in fact, for those of you who own sole proprietorships, you find that at some point where it grows too big, you want to corporatize. You cannot convert your sole prop into a company. You have to sell the assets and the business of the sole prop to the company in exchange for shares. Yeah, in this case, it's largely the same. I said that there are no shares, right? Your registered society dissolve. Okay, it passes a resolution to form the CLG and to transfer all of its assets to the CLG. Then the CLG is formed, and constitutionally, you make sure that the two are the same. Of course, like my personal mantra, talk to kitchen god, right? Always make sure your sector administrator is aware of what you're up to, okay? And once the CLG is formed, appoint your board, set up the membership, right? And of course, I say that because you don't need all the members in place in order to incorporate. All you need is one member, one director, yeah, and one company secretary. So once that is formed, you invite the rest of members to join in, take over the assets as a donation from the registered society to the CLG. So that largely is the process involved, okay, in very, very broad terms. Of course, the process in of itself is a bit more granular. It is a bit more, there's a bit more finesse to it. Yeah, and of course, it can take quite a fair bit of time. In my experience, right, and I have actually converted one of these previously from a registered society into CLG, and that was the Guide Dogs Association. I was a member and a director as well at the time. The members at the time reached a consensus, and it was very fast, right? Because the registered society was fairly new, and there's really no love lost, you know. So we, personal liability, you know, the one that we just let it go, right? But in some other cases that I've encountered where maybe the organization has been around for like decades, you'll find that there is a certain level of sentimentality. I'm not saying it's a bad thing, okay? It shows the passion of the people involved. And you have to tread very lightly. You have to be very sensitive, because these are the people who have served the organization well. And it would not be very sincere if we just, you know, got rid of them. Yeah.
Thanks, Samuel. I think one important question that I would like to quickly answer for a particular audience member is, what is a sector administrator? Perhaps Peggy, what is a sector administrator?
Okay, perhaps we look at it. Let's start from the very beginning.
Sure.
Charities are divided in our landscape in Singapore in just generally in these sectors. We have education, religion, community. So, for example, within religion, you have Hindu Endowment Board, for example. You have the and then for education, you might, you know, any charities that is education based. And then as far as community is concerned, you have those that are health based, relief for the elderly, the disadvantaged, the vulnerable. Then let's not forget arts and heritage, and then sports. Also, there are charities that are involved with the environment. So for every one of these charities, we can largely categorize them into these sectors that I've just mentioned. And for example, if you have for example Francis's charity, right? So
under healthcare, yeah.
Correct, healthcare. So healthcare, the sector administrator would be the MOH, the Ministry of Health. If it was say child-based education, or for example, say providing, looking after the needs of the poor and the disadvantaged, then it would be, then the sector administrator would be the MSF. So that's what we mean by sector administrator.
Thanks, Peggy. I think one question that comes from the audience member is, can we maintain IPC status in the process of this whole transfer? You have a society who has IPC status, and then you're going to move everything over to the CLG. Not sure, given that what Samuel has shared, actually a CLG is a separate entity from the society. So presumably the CLG needs to apply for IPC status. Is that how it works?
Yes, you are right. But of course, you'll find that once your sector administrator is involved, the path, so long as you are still doing the same thing, the path will be smoother. Yeah.
Thanks,
Same
Samuel.
constitution of board, or you have not introduced any wildcard elements. It should be fine. Yeah.
Just from personal experience,
yes,
that's where Peggy said you can also talk to the charities unit because while we appreciated the sector administrator, but the sector administrator has a certain process they follow.
Yes. And
sometimes the charities unit is able to, bridge that. If you don't want any delays, they can just smoothen the whole thing. I cannot go into details because they will fire me if I go into details, but offline, buy me a beer, I'll tell you more details.
Thanks, Franz.
Perhaps, Serene, I just add in this scenario. Look at it as a journey, and look at it as a journey that you have different people walking together on this journey. So charity, sector administrator, and the charities unit. So if there's a conversation with all three and you're all walking this journey together, then it makes the journey, when you go on a hike, if you do it alone, it can be quite jialat, right? But if you do it together with your friends, it might, it does become pleasurable.
Thanks, Peggy.
Oh, sorry, can I add something? Serene?
Sure, Francis, go ahead.
I think it's really important to mention this. So you must know your society's constitution very, very, very well. Okay, so in our case with ADA, it is explicitly written that our assets can only be transferred to another IPC. So which basically meant that we could not do any asset transfer until the CLG was awarded IPC status. So in reality, we incorporated on 1st April 2021, incorporated, open bank account, so theoretically we are alive, but there was no way to receive the assets. So we had a transfer deed, and the transfer deed had to be dated effective 1st September because we got our IPC on August 18th. So we could, it was only you because it's written in our constitution. Now, if it's not written in your constitution, check with your lawyers. Maybe you don't have to wait for the IPC status, or maybe you should still wait. But in our personal case, it is very explicitly written.
Thanks, Francis. Such a good reminder. Do check your constitution. And of course, each society's constitution is, of course, very different. Well, Francis, I think you shared a lot of useful tips. A very popular question from the audience is, roughly how long did it take for you to go through this exercise?
Oh, okay. So internal discussions. Okay, first, I know of charities that kept their name, right? And then they moved the legal entity, changed from a society to a CLG, but they more or less kept the name. For our case, we changed the name as well. That's why we had a double whammy, more work. So we started all these discussions at the beginning of 2018. We had a first AGM where we presented the story in September 2019. So 1.5 years later, we felt we were ready to tell the story, right? Then in AGM September 2020, we passed the resolutions, two resolutions to incorporate the CLG and to transfer the assets once the IPC. So we get the approval from the at the AGM first, right? Then based on that, we immediately appointed a company secretary. That's quite important. You need a company secretary as well, who knows how to do all the filings, and he helped us to reserve the name Dementia Singapore Ltd as well, right? You can reserve, I think it's like $15. You just chop it first, right? And then got the constitution approved by sector administrator. That's the other thing. Your constitution needs to be approved by the sector administrator. Then incorporated on 1st April 2021. Right? Then we applied for charity status and IPC status. That took about 5 months. Then we did the asset transfer on 1st September 2021. At the end of September 2021, we had an AGM again, and we opened up the third resolution, which is approval from the members to dissolve the society upon the final audit. So because the final audit could take some time, I mean, you need to talk to your auditors as well to work out your effective date of dissolution. So finally, our effective date of dissolution is 15 June, which just passed, 15 June 2022. Okay, so I'm telling you this whole journey, but really from a risk point of view, what is important is for us was 1st September 2021, where we transferred all the assets. So Dementia Singapore as a CLG became live on 1st September 2021, and all assets were transferred, which means the society was a shell. Okay, so from a risk point of view, you just make sure that you continue your services, you got enough money, pay your salaries, and do all these things, right? If you don't get your third resolution passed, if for whatever reason your members say, you know, we love the name ADA so much, we don't want to dissolve the society, I think it's a low risk. It's just very cumbersome because administratively you have to do, you know, the annual returns and all, but it's no longer a charity, it's no longer an IPC, it's just a society. A very, very low risk. So don't fret, don't get stressed over in case you don't get the final vote, because while at AGMs usually say majority present plus proxy, the decision will pass. But check your constitution. Ours was written explicitly that 60% of all voting members, whether or not they attend the AGM, 60% of all voting members need to pass the resolution to dissolve the society. So that was a big, big, big risk, which we were not even sure we could reach 60%.
Thanks, Francis. And I think as Samuel has alluded earlier was, you know, sometimes depends on how long the society has been around. If it's 1 year or fewer than that, or quite short, there's less sentimental or nostalgic views on that. Peggy, you know, given the talk about support and the cost, does the Charity Council provide any support for this transition?
Okay, thank you for wording that question in that way. Support, yes, but to answer the unasked hard question, does the COC fund this exercise of say converting, of transitioning from a society to a CLG? The answer is no. But what type of support is provided? Yes, because there is a fund called the Charities Capability Fund, and this fund is going on all the way until 2027. This fund, I think there should be a slide for it. This fund provides monies for different grants. There is a training grant, a consultancy grant, Infocom IT grant. Yeah, thank you. So if you look at this slide, these are the grants for which this fund can be tapped on, and charities, all the charities need to do is to go onto the portal and make an application. Of course, the steps are set out there. The reason why I say these grants are available and charities should avail themselves to it is because when you go into each of it, for example, the consultancy grant will pair you up with consultants that you can ask about to see whether or not, you know, they can give you assistance and whether or not the funds can cover it. because the COC does not pay you and say, okay, your process, let's say, you've appointed your private lawyer and your lawyer charges you this amount, we will fund this. No, we do not do that. But we give you grants to help you better your entire process and your management team and in doing so, it recognizes that you may need training, you may need to consult consultants. So that's what we do. And then we also have partners because we work with partners with the umbrella bodies for example, and there's another slide for this. So if you see this slide, these are the partners that the COC works with. If you can go down that slide some more. So for example, let me just put in a plug for the Law Society Pro Bono Services, of which I'm proud to say I'm a part of. So for example, LSPBS provides legal guidance, trainings, you can read that, okay, and advisories such as amendment of constitutions and compliance with laws. So for example, if you want to go and talk to lawyers, okay, or talk to any of these parties, because there's also another partner that we have is the Chartered Secretaries Institute of Singapore, which provides free training. That's on page 1. Free training and consultation clinics on submission requirements, governance matters, for example. So on the one hand, the support is given by one, there is the Charities Capability Fund that charities can tap on, and two, a whole list of these shared services partners with whom charities can go to and can tap on in order to get assistance. So please avail yourselves to that.
Okay, thank you, Peggy, for that. So good to know that there is some support out there, and you just need to, I suppose, do the legwork and look into the respective grants and try to apply. So let's move on to the next part of the scenario. So finally, Happy Charity sets up the company limited by guarantee. So the president asked Amanda, what would happen to the society? So Samuel, I think earlier you'd had kind of answered this in that the society would have to come to an end. But how does it come to an end? I mean, is it a resolution or how does that work?
Yes, you actually have to dissolve the registered society. And that necessarily means that you bring the life of the registered society to an end. In some cases, it might feel a bit sad because of sentimental value, but the life or the work of the charity can actually continue. Yeah. So in that regard, that there is really no loss, right? Because the purpose exists. The flame is burning. It's just passed on to another torch. Yeah.
Thanks, Samuel. I actually quite like that analogy. An audience member has asked, is there a time limit in terms of trying to end the society after the CLG is set up? Samuel, in terms of legal requirements?
Actually, there really isn't a time limit per se, but Constitution might say something else. But for me, right, the consideration is cost, right? If you don't end the registered society early enough, you might actually trigger the need for another AGM or another set of accounts because it, is completed another financial year, So why incur the extra cost, But maybe a word of caution is this: always count your eggs first, or rather, maybe I put it in a better way, count your costs before you build your tower. Yeah. So if you are good, you want to form a CLG, roll out promotion, roll out education, guide your members along, and stakeholder management is actually a very, very critical part of the process. If your stakeholders are fighting you, kicking and screaming all the way, right, you're going to have a heck of a time. And guess who benefits? The lawyer, while you all fight over the cow, the lawyer down there milking the cow, So, we charge for our work and for services rendered. Yeah. So, to be honest, there is actually no need for you to engage a lawyer unless your board is clear But of course, sometimes you might want a lawyer to come in and to explain. Yeah, but of course, this is really at your discretion. Yeah.
Thanks, Samuel. Francis, I guess any thoughts to add based on experience in terms of trying to end the society?
Okay, so if you try to dissolve a society, which happens to be a charity, you first need to deregister the society as a charity, first step, right? Then your sector administrator, there are some documents you have to submit, right? Then they will issue you a letter of no objection, right? Then you need to take this letter of no objection and submit it together for the dissolution. So it's two steps, huh? Deregistration of charity and then dissolution, okay? What happens to the society member? I saw Corina ask a question. Hello, Corina, I haven't seen you for a long time. You talked about, I mean, I think we're at the same frequency. We talk about how can, so we had about 200 members, 100 plus, and then in the end now as a CLG, we have 9 members. What happens to all the other members? Some of them can be donors, right? Some of them are active contributors, they're quite happy. So they don't need necessarily to be members of the CLG. We offered a creation of a platform. We call them, please continue to engage and support as a guardian of Dementia Singapore. So as the Guardians of Dementia Singapore was a platform we set up for them, which the acronym was quite nice lah. Okay, so we said, we want to move you from society members to be gods. And then we welcome them to continue to contribute. So again, our members were majority, 99% of our members were not sticky about voting rights. So it made life a bit easier, but they still wanted to continue to help. So we also have an avenue for them to help if they want.
Thanks, Francis. Peggy, does the Charity Council need to be notified in terms of the winding up or the ending of a society?
Yes, they should. The charities should, given that the charities unit oversees all charities in Singapore. The charity should, because even before the charity deregisters itself, before it converts or transitions to a CLG, this entire exercise, as we said earlier, should be done together hand in hand. So this ending part of it should similarly, notification, although not mandatory, ought to be done because we are overseeing all the charities. And on top of that, we must also not forget that the very important principles of disclosure and transparency and public image apply to all charities as well. So if a charity like Happy, if it's in the process or if it has deregistered itself, and it's in the process of transferring its assets, for example, they're disgruntled former members who were not even consulted. There was no messaging sent out at the start when this exercise was even thought about. This actually does not bode well. And this means that the best practices as far as disclosure, transparency is concerned, there is a lack there. And the culmination of it all is what then becomes of the public image of this charity. So before it is being done, please consider all these.
Thanks, Peggy. And I think that goes very neatly into the next part of the scenario where, as you had mentioned quite rightly, that Happy Charities beneficiary heard that the society is coming to an end and is anxious that the charity is shutting down. So Francis, any thoughts on how to provide comfort to the beneficiaries? Because I'm sure rumors will go around that, the society is coming to an end. Any tips on how you went around dealing with that?
Okay, assurance. We gave a lot of assurance to our beneficiaries, and our beneficiaries include the family members because they are the caregivers of persons with dementia.
Yep.
We tell them it's the same program, same services, and same staff. We also ensure that all our staff, client-facing staff, were trained to support them through the change. You also need to change like payment. So when they make fee payments, many people just write the check the same way or do the electronic transfer the same way the old bank account, and the bank account has been closed, right? So it was really guiding them so that there was as little pain as possible. And really, it was relentless communication to all stakeholders. We just communicate. I think one of the, so I got a couple of things I think is quite useful to raise. PDPA, sure. Right? PDPA is a big thing. So in a way, because we had a lawyer, the lawyer could help to ensure that we did everything correct. One of the things we didn't want to do, and thank goodness, under the PDP, the Act allows an exception. Normally, if you want to transfer, you need consent. But we've got 10,000 people, our beneficiaries. We cannot be asking consent from every single one. So there are exception clauses, which our lawyer found out for us, and we followed those guidelines. No consent by notification, etc., etc. And where to publish this, how long to publish it, what document, how to write. So they drafted all these for us. I think that was money well spent, because if we were to try to create ourselves, we may not do things the best practice or the right way. Another point, which that's what Peggy said, right, is that the elephant is in the room. So how much does this whole thing cost? I cannot talk about legal fees, okay? So legal fees,
that's simple. Is
you can go from Samuel,
and one leg lah.
From Samuel will be zero, right? You go somewhere else. But I can tell you, when we asked for some quotations, the highest quotation we received was $200,000, which we obviously said no, right? Yeah. But then we use our contacts. So I'm sure you have board members, you have your network, managed to find some contacts, and we got not pro bono, but low bono, very, very low bono fee. So that's the lawyer's fees, right? Then we got a couple of, novation. You need to transfer your agreements. I tell you, you will come across some of these third parties, like our landlord, for example. Our lawyers already drafted the novation agreement. They said cannot, must use our lawyer, right? And we had to pay for the novation fee. It's less than 1,000, but and then when you look at it, it's like 99% the same, right? But the one got their lawyers chopped. Yeah. So be prepared to incur up to $1,000 per novation agreement for some. I would say we hit about 5 or 6 third parties that insisted that their lawyers draft the novation agreement, and we had to pay for that. Okay. Then the other thing is, don't forget your IT systems that need interfacing with MOH or MOE or MSF. If you have grant arrangements, you need to adjust all these. So there could be some IT costs as well. And if you're changing name like us or changing corporate color, then you have all your signages, your collaterals, there's costs as well. All in all, I can say we spend no more than 40K for the whole thing, right? Because I mean, for the IT side, we were already going through our digital transformation, so we tapped a lot on the NCSS Tech and Go funds. So we just incorporated everything. But if you exclude IT, everything else came out to no more than 40K.
Thanks, Francis. I'm sure that everyone appreciated that so-called indication, even though it may not be on point, because every charity, depending on their size, it may actually entail a different scope of work or legal work needed for that. So, for our discussion this afternoon, Samuel, it sounds like stakeholder management is critical to ensure a smooth process. So, Samuel, I think we've heard about members. Who do you think, besides members, are perhaps key stakeholders, and what are their typical concerns?
I'm sorry, could you repeat that again, please?
Sure. So I was just saying that basically there's a number of stakeholders that we have to handle. One of it, of course, is the members. Besides the members, who else do you think is good to keep in mind in trying to work out this process?
I think we should never forget the clients, or your case, your cases, because while the switch from one entity to another may not necessarily mean a drop in quality of service. Practically speaking, there could be maybe a loss in translation, or maybe there could be a drop in service because of that transition work. So this is, however, something that can be managed. Yeah, I think other than the members, the expectations of board members or the council should also be managed as well. That I had a previous experience where actually the paid staff were very keen to convert, so they invited me to speak with the board. But at the board meeting, I was this happened many years back. I was actually chastised, for even suggesting the need for conversion. And but again, maybe it was really the fact that the board were caught off guard, or there was not sufficient communication, and maybe there was a misalignment as well, right? So I feel that other than members, your clientele, very important. Keep them updated. Make sure that there is mitigation of the drop in service. For the board members, our council members, definitely, not to say they're egotistical, but it is important to make sure that you don't accidentally step on anyone's toes while proposing this switch, because some of them could have been there right at the beginning. They were the ones that put brick and mortar together to form the registered society. Yeah.
Thanks, Samuel. Peggy, do you have anything to add?
Sorry, this is in respect of?
In a sense, do you have anything to add in terms of any important key stakeholders that that should be handled? Okay, so I think we've touched on so Samuel said that, okay, please remember the clients.
Yes,
Please also remember to deal with the directors, because, as he mentioned, some of the directors may be founders, they founded this baby since 20, 30 years ago. So besides the directors and the clients, is anyone else that comes to mind in terms of stakeholder management?
Yes, because we work in the environment, right? So there would be the beneficiaries, which are the clients, then the board. But consider also who the donors are. Because if your donors have been with you for a long time, you would want to as a charity, ensure that you connect with your donors to let them know, seek their views. And also, if you are a charity that is in the public a lot, would it be useful to also have some sensing as to what the public thinks about it? For example, I mean, of course, it may become unwieldy, but again, our favorite word is always "it depends," and it's our favorite word because it is true. It really depends on the situation. So those are the other two facets of stakeholders that you need to consider. The general members of the public, and your donors. Consider also your volunteers. Volunteers are also part of stakeholders. Do they, because if your charity relies heavily on volunteers only, and your volunteers don't know about this, or they have reservations about this, ought they to be heard by your board? How can the messaging be carried out? Consider all that as well.
Thanks, Peggy. So we've come to our Q&A segment. So to our audience members, if you have any questions, feel free to submit them through the Q&A button. So I think I received quite a number of questions, I think seeking clarity, Samuel, about CLG. So for CLG, I think earlier I was mentioned that for CLG, because it doesn't hold shares, so it's a company limited by guarantee. So in a sense, CLG, it cannot be a subsidiary of another company?
Yes, it cannot be. It's inherent in the way a CLG is created, that there is no possibility of holding shares in a CLG. You are a member, okay, but the member's obligation isn't to act as a shareholder, but to act as a guarantor. Hence, company limited by guarantee. Yeah. So you will not be able to have a holding company over a CLG, but from the other extreme, right, it is possible for a CLG to hold shares in the company.
Got it.
Yeah.
So CLG can be a holding company because it can own shares in another company,
yes,
potentially.
Yeah.
But a CLG, due to it being a company limited by guarantee, it does not have shares.
Yes, it
so
cannot be. Yeah.
So it can't be. Okay.
Now, I think a distinction has to be made here, yeah, because some charities or some organizations out there are actually created by a statutory act. Like, for example, some of the more established churches or some, I think some religious organizations, they are created by an act of statute. Yeah, so they do have powers to hold. Yeah, but they are not CLGs per se. Yeah, so I think that is a whole area of discussion, which I don't think we have time to go into today.
Sure. Thanks, Samuel. I think basically the important takeaway is that it very much depends on your society, because the different charities and how they are set up or how their origins are so different from each other. So perhaps they may need to seek more specific legal advice if they're looking in terms of how do they control or how do they, whether they're subsidiary holding, etc. I think an interesting question that arose is, well, perhaps for the charity, they would like to remain as a society, and instead they'll set up a CLG and port over some things to a CLG. But it sounds like from what you say that, how does a society exert control over that CLG? Samuel, any thoughts?
How you exert control over the CLG?
Yeah, so basically the charity remains as a society and decides, you know what, let me spin off some things, I'll set up a CLG. But how do you try and maintain some control over the CLG?
Well, the most rudimentary way of doing it is to staff it or to pack it with your own guys, right? From the earlier organization. Another way to do it is perhaps like what Francis had alluded to earlier, is to define the purpose of the gift or the donation. Yeah. So the controls that you're looking at isn't really like statutory control, right? Whatever governs the company limited by guarantee is actually set out in the Companies Act. And you'll find that the Companies Act actually, to a large extent, do not differentiate between directors and members of a CLG and directors and members of a CLS, a company limited by shares, right? So I think from that perspective, that's the extent of the control, legally speaking, right? Of course, Code of Governance plays a part, and you would also want to look at all these extra legal kind of solutions, like what I mentioned, staffing it, and also limiting the purpose, I don't know, Francis, what do you think? Peggy, what do you think?
Okay, if I'm not wrong, I maybe someone from LS PBS can say something, but Law Society Pro Bono Services used to be part of Law Society.
Yes, it is.
And then they decided that they want to be a separate legal entity, a CLG. And then they decided that the member is the Law Society. Yes. So maybe that's one way. If a society wants to be a member, it just takes in that one member.
Yeah, I recall voting on it.
Yeah, okay.
At the same time, besides membership representation, which both of them have spoken about, consider also aligning your governing instruments to make sure that they are both aligned together, to make sure that the objects are similar and that the terms of the Constitution, M&A, are also similarly aligned. That's another way of doing it, besides the personalities.
Thanks, Peggy. Another question is perhaps, for some of the audience members, they're very used to a society holding AGMs, EGMs. So a question is, for CLG, do they have any AGMs or any EGMs? Samuel?
Yes, certainly. I think we have to view AGMs, EGMs as a means of getting consensus from your members, and of course, and part of the thing that goes with it is to ensure that there is a level playing field, hence a need for a notice. Yeah, I think this is really the fairest way to call for consensus. And actually, frankly speaking, this requirement exists whether it's a RS or whether it's a CLT. Yeah.
Thanks, Samuel. I think another question that we have, if you could give me a moment, is that, the concept of membership, and maybe this is just a broader thinking question, maybe not strictly legal. So and some audience members mentioned that, yes, when they're society, they have membership, but in a way, it's a tool for them to make people feel as a sense of community, to make them feel that they belong. So they think if they convert to CLG, although noted that, it's much more practical, that a member is maybe one or two persons, any ways which they would still like to have members, maybe not call them as members, but, so that they can continue on that sense of community and, make I suppose as supporters feel part of the charity's purpose. Any thoughts? I suppose maybe Francis?
I think I shared earlier that they can. You see, those members that want to continue to be involved and to contribute. I mean, let's look at motivation first.
Sure.
There are people out there that are very motivated to help. They don't ask for anything in return. They will continue to help. And there will be another group that will be saying that, oh, I really need my voting rights. I wake up every morning because voting rights is so important to me. Then hopefully it's not 90% of your voting membership in your society, but those few that really want to vote, give them a chance, maybe you want to talk to them about, and you will know your members, right? Whether they are attending AGMs. I mean, if someone says, I really believe in my voting rights, but has not attended AGMs for the past 10 years, then, you have a right to question that, right? So involvement you can continue to be involved in many ways. And for us, we set up a platform for them to continue to be engaged as a community. I have to say, later my colleagues changed it because Guardians of Dementia Singapore was in the end dropped. We call it Champions of Dementia Singapore, which is COTS. To me, not as fantastic as GOTS, but there's still something if they want to continue. But I must say that also the members say, yeah, that'll be nice, but nothing happened as well from them. So we throw it back. We say it has to be driven from you. You are ex-members. You want to contribute. You want to be proactive. So you take the lead. You tell us what are your ideas, what are the projects you want. We will support that. But now about 7-9 months past, we haven't seen a single idea popping up. After a few Zoom sessions, nothing seemed to happen. So you must just offer platforms, but it's up to the individual member how they want to continue contributing.
Thanks, Francis. That's a very good and practical way. As you suggested, a lot about the marketing as well as making them feel involved. So just because you become a CLG, it doesn't mean that all the people who are members suddenly drop off. They're still part of it, but perhaps you may call it under other terms, GOTS or COTS. Another question is a little bit more about corporate governance. So in terms of directors of CLG, is there any requirement to change the directors from time to time? Maybe I'll ask Samuel from a legal perspective.
Yes, from a legal perspective, it is always good practice to do a rotation of your directors. The rationale behind it is that you do not want one director to become entrenched. And this rotation, right, simply means that when it's your turn to be rotated, you stand up and quit or resign from office, and you stand for re-election. Yeah, that's in the gist of it, the simplest possible answer. This rotation is usually carried out by a 1/3 basis. So every year, 1/3 of the board will stand up. If you cannot divide equally, you chop the person in half. No, I'm just kidding. If you cannot divide equally, you round up instead of round down. Yeah. So that 1/3 will stand up and then ask to be or step back from office and ask to be re-elected. For the first year that you have formed this CLG, how do you determine who goes first? Right? Conventionally, we always go for the oldest one. Yeah, the oldest board member. We rank them according to age, and if there's like 9 of you, then the 3 oldest ones, followed by the 3 middle ones and the 3 youngest ones. So you just rotate on a 3-year basis. Yeah.
Thanks, Samuel.
Yeah.
Peggy, does Charity Council have any thoughts in terms of board rotation, or there should be a cap on how long a director stays on the board?
As a matter of fact, in the Code of Governance, the recommendation is that all board members should offer themselves up for renomination and re-election every 3 years. So that is part of the practice that is being recommended, recommended in the Code of Governance. And just on the Code of Governance, there was a question I saw that asked for a link to this. Is actually, I think LSPBS will provide that link, but if you go into the charities portal, actually for charities, there's a wealth of information in there, and the Code of Governance is one of them in there as well. So it's in the charities portal.
Thanks. Another question is, so now we touched on the directors. Next is members. Members, given that they have a very more limited and different role for CLG, is there any requirement for members to be rotated as well, Samuel?
For CLG, for members to be rotated, no, there really isn't that kind of requirement on members. Simply because members perform a very, very different role from that of a director. And I noticed in the question set that there had been some confusion here, or maybe some queries are relating to these roles. Now, we have to look at these as separate roles, which can reside in the same person, or it need not, right? So you can wear your hat as a member, meaning to say, as a member of the CLG, your role is to participate in the decision-making at the general meeting level, right? As a director, you are responsible, for want of a better word, for the day-to-day operation and the direction of the organization. So these two are very separate and very distinct roles. Yeah, you find that as a director, even for companies limited by shares, right, you'll find that sometimes directors commit offenses, they commit fraud, or they end up doing things which are actually not in the interest of the company. So maybe they breach fiduciary duties or things along those lines, right? But as a member, you don't really have that that ability, right? You are not responsible in the sense for the actions of the directors, and you may actually remove the directors, if called upon, and if that question is put before you. Yeah, so very distinct roles. Yeah.
Thanks, Samuel. Thanks for clarifying for that. Yes, quite a number of audience members were a little confused over what's the role of a member versus a director for a CLG. Given our discussion where we talked about, certain benefits to basically changing from a society to a CLG, one audience member asked, well, if I'm starting a charity now, would it make sense to just go straight into a CLG as opposed to trying to start off with a society? Samuel, any thoughts on that?
I want to echo Peggy here and invoke our favorite catchphrase. It all depends. Yeah, it all depends. However, if you ask me to look at it from a more cold-blooded way, the CLG represents certain efficiencies and efficacies, right? You do not have to appoint a 10-member board, right? You do not. You are not restricted in many ways to just a certain category of members. For example, I think registered societies preclude foreigners, if I recall correctly. But CLGs don't have that statutory requirement. So it is possible for members of a CLG to be foreigners, to be EP holders, right? So it's in a way more inclusive. So it really depends on what you need. Yeah. In some cases, in fact, in most cases, we find that a CLG is more cost effective. Yeah. Although you do have to hire or appoint a company secretary, but by and large, the speed at which you can do things is a lot faster. Yeah.
Thanks, Samuel. So a question about, I guess, corporate governance is high on everyone's mind. For society, typically you have a president, vice president, a secretary, a treasurer, etc. But for a CLG, yes, you have a board of members, but would you similarly have such titles, president, vice president, treasurer, etc.?
Well, technically, no. But of course, there's nothing in the Companies Act that precludes you from giving more grandiose sounding titles. Yeah. But by and large, everyone who's on the board of directors is, in essence, a director. Yeah. So that there is no need to separate the roles. In fact, I think this is one of the common misunderstandings, that when you shift from a registered society to a CLG, you must replicate that structure. Yeah, but it is not necessary. You'll find that the board of directors work just like the any board of directors, even for companies limited by shares. You make decisions together. You may apportion roles and responsibilities, but ultimately you make decisions as a board. When I was on the board of the Guide Dogs Association, or GDS as they are known now, what we did was, amongst the 5 or 6 of us, right, we would dole out responsibilities, So naturally, being the lawyer on the board, I was responsible for legal and compliance. I had a secondary role to help HR, which is held by another director. So I'm like sort of like a backup to him, because the two issues tend to conflict together. So it is up to you or your board to decide how you want to spread the load. Yeah, but there is no requirement to have that kind of fully demarcated, like treasurer, assistant treasurer, and 2 VPs. That is really not necessary.
Thanks, Samuel. Perhaps this is the last question, being mindful of time, and perhaps I'll ask this to Francis. You have experienced going through a society, you've now experienced going through a CLG. Do you have any pain points in operating within a CLG structure, and any learning tips on that?
Well, operating within the CLG structure, I have not encountered any pain yet. So I think we're all very happy with the decision. But I want to come back to one point earlier you mentioned about, or someone asked a question about AGM.
Yes.
So and maybe Peggy and Samuel can chip in, but you still do need AGMs, because there's this thing called standard business in AGM, where the AGM members are not the board of directors, but the members need to approve the auditor. Right, it's a standard business, and in fact, you need to submit this approval to the sector administrator, right? So you still have, this is what we call standard business.
Yeah.
Approval of the audited accounts. So even the board of directors has approved it, you still need the members. So the AGM calls for this. It's not a board meeting, it's an AGM. And then you can also, and I think it's I'm not sure you must or you could appoint the board members during the AGM, right? So I usually have these 3, what I call standard. Of course, as a society, what we have will be election of the board members.
Yes.
But now I don't have election, it's appointment of formally appointing the board members at AGM. That's what we haven't run the first AGM yet as a CLG. So I'm just saying that this to us are the 3 standard business items.
All right. You're right.
An AGM.
Yeah, Francis, I do agree with you. I find that the best guidance you can take, right, is actually from how a company limited by shares is being run, because the statutory provisions in the Companies Act that applies, right, are actually applicable to both forms of companies. Yeah. So yes, there will be that standard business, which are subject to ordinary resolution. Yeah. There could be, of course, the structure and the process of calling for meetings is largely the same as well, subject to the code of governance. Yeah.
Thanks, Samuel. So the webinar is coming to an end, but before I end off, any last words from perhaps Peggy, Francis, and Samuel? Perhaps Peggy, do you have any last comments to add?
I just want to assure charities that the landscape that we are currently in is very different from it was years ago. But charities should also bear in mind that they are not being forced to do anything. So it really depends on what your charity's objective is. If, for example, and I've seen some questions, Lian Sheng and Karina, if it's an arts-based one and you feel that you really want to have the involvement of every member and the perhaps anonymity of the CLG will not cut it, then by all means. So it really, at the end of the day, is how your charity is being run. And if your charity is run well and effectively, then your charity will be able to meet its goals, as well as to connect well with all of its stakeholders. And it's not a scary process.
Thanks, Peggy. Good reminder, the CLG is just, again, it's another structure you can explore, but feel free to stick with society if that is what works for you. Francis, anything to add?
Well, the first thing I wanted to say was Peggy already said, right? but really, it's a very, I really tell you, for a large charity that's existed for 30 plus years, it is a very tedious process, okay? It's not rocket science, but it is tedious. So if you don't need to become a CLG, if your society is running fine, everything is fine, there's no real reason, then do consider not changing, right? So you must have a compelling reason, okay? The second thing is a whole of organization effort. It cannot be one or two people saying, hey, it's really good, then they end up with all the work. You need the entire organization. And that's why I would advise, if you can, pick up some skills in change management. You don't need to be ProSci certified or what, but go Google, how to address resistance, how to address all these things, and pick up these skills to try to unblock and unlock and get buy-in. It really works. I went for a course, so I know I use that quite a lot for change management. And the last point is really communicate. No such thing as under communication. Better to over communicate. And someone say, hey, 很烦啦, 很烦. Never mind. You just have to tell everybody, this is what we are going through. Okay, that's it.
Thanks, Francis. Samuel, any other remarks?
I think I echo my two colleagues here. It is really, don't do it because the cool kids are doing it. Yeah, so find out the reasons why, and how I would approach it is ask yourself the why questions. Why would you want this? Why is it good for you? Why do you think your members will go along with it? Ask the why questions. Satisfy yourself that this is really what is good for the charity, right? And good for your clientele. Don't convert for the sake of conversion. And as far as I know, the COC and of course all the sector administrators do not have that one preference over the other. Yeah, from my personal experience. I think as we travel on this journey of volunteering and of charitable purposes, right? It is very important to always focus on what is important. In a way, the form and the structure do take a backseat to the work that you're doing. And in this regard, I just bottom of my heart, because I've been involved in charities myself from the operational end as a director, I want to say, well done, everyone. It is not an easy journey, okay? And it is something that I think, you have my respect that you are involved in the charity, yeah, because it is difficult to just think, not just for yourself, but for other people as well. So well done. Yeah.
Thank you, Samuel. And with that very encouraging note, this brings our webinar to an end. And after this webinar ends, a feedback form will pop up on your browser for your completion. We appreciate your feedback so that we can improve our future webinars. If your charity needs legal advice, please email lsps at assistmpos@lawsocprobono.org.sg. And with that, on behalf of the Law Society Pro Bono Services, Charity Council, and Office of the Commissioner of Charities, we would like to thank our speakers again and thank all of you for spending your time with us. And we hope that you have a great week ahead. Bye.
Thank you.